Welcome to WG University, which is Weber Gallagher's series of educational programs. This is our Civil Rights and Municipal Liability webinar. I'm Joseph Goldberg, and I'm presenting today with Charles Starnes from our Philadelphia office. If you would like to view this webinar again, share it with others, or see other WG University programs, please visit the Weber Gallagher website at www.wglaw.com, and you'll find copies of this presentation as well as other presentations under the WG University page. Also, please feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is entitled Wrongful Convictions. Let's get started. Charlie?
Thank you, Joe. As Joe stated, we're going to be discussing wrongful convictions today, which is one of the more controversial and difficult claims to defend against for both police officers and prosecutors. Now, just a quick view from the other side of the aisle here. Recent studies have shown that as many as 113,000 innocent persons could be currently incarcerated within the United States. Similar studies have shown that up to 1.4% of all death row inmates are actually innocent, and as many as 340 innocent persons have been executed since 1973. Again, since 1973, 144 death sentence defendants have been exonerated. The main causes of wrongful conviction are witness misidentification, perjury or false accusations, official misconduct, which can include a number of things such as withheld or manufactured evidence. False confessions are surprisingly common, with witness misidentification playing a role in roughly 70% of all wrongful convictions. Now, the Innocence Project, which is perhaps the most well-known source of information and litigation regarding wrongful convictions, has provided this. As you can see, of the first 225 DNA exonerations that the Innocence Project played a part in, roughly 72% of those cases involve witness misidentification, improper forensics at roughly 52% of those cases, and again, 23% of cases involve false confessions. And I recognize this adds up to more than 100%, but that's because in each case there tends to be more than one issue. Now, general overview of liability. The federal government, at least 30 states, and the District of Columbia all have financial compensation statutes which provide a set amount of compensation for those that have suffered wrongful convictions. This tends to be a set amount, and some states have also included vocational or educational assistance for those coming out of incarceration. Now, in addition, and this is going to be the focus of our webinar today, will be civil rights suits that are brought by victims of wrongful conviction. Just a few examples of some settlements we've had, and try to inject a little levity here in a very serious and difficult subject. So Mr. Barry Gibbs, who's not the Barry Gibbs of the Bee Gees, received a $11.8 million settlement from the state and city of New York after he served 19 years after being wrongfully convicted of murder. In that case, the witnesses recanted their statements, which had been coerced by an NYPD detective who was later convicted as a mob hitman. Then in the case of Mr. Anthony Ortiz and Danny Colon, they received $9 million from the city of New York. They each served 16 years of their murder convictions before they were overturned. In that case, the witnesses who had testified in their cases later recanted they had been received preferential treatment in exchange for their testimony as part of plea deals. While in prison, Mr. Colon met Jabbar Collins, who had also served 16 years for murder and received $13 million after witnesses recanted their testimony. The witnesses in the Collins case had been coerced actually by the prosecutor, who had threatened them with both jail time and physical violence in exchange for to coerce their testimony. Mr. Terry Harrington and Curtis McGehee were wrongly convicted of murdering a retired police officer in Iowa. They received a settlement totaling $12 million. In that case, the prosecutors had failed to turn over to criminal defense counsel that there would have been an alternative suspect who had recently argued with the deceased victim, and during a post-conviction relief hearing, police officers and prosecutors testified that there had been no alternative suspect. Now, what we'd like to do now is sort of move chronologically through the claims that could be brought as part of a wrongful conviction claim. First is a false arrest. We have elements of arrest and a lack of probable cause. This cause of action accrues at the time of arrest. As we're discussing that when the cause of action accrues, this is important for recognizing when the statute of limitations will begin to run on each claim. The damages for false arrest are limited to those arising out of the arrest itself through the initiation of legal process. We also have false imprisonment, which largely mirrors false arrest and is considered by courts at the same time in their analysis. And there we have an intentional confinement in the form of restraint on a person's freedom of movement and, again, a lack of probable cause to detain. This cause of action accrues when the imprisonment ends, whether that's through release from confinement or when the subject becomes held pursuant to legal process. The damages there are limited to those arising from the detention itself through the end of the false imprisonment, which is either a release from the detention or, again, through the initiation of legal process. Now, malicious prosecution is a claim that is evolving. Federal courts have not stated definitively what the cause of action will look like throughout the United States. As such, federal courts will look at the common law of the state in which the incident occurred to define the elements. The basic elements are that the defendants initiated a criminal proceeding, that the proceeding was initiated without probable cause, the criminal proceeding ended in the plaintiff's favor, and that the defendants acted maliciously or for the purpose other than bringing the plaintiff to justice. Some jurisdictions, which include the Third Circuit, which would cover Pennsylvania, New Jersey, Delaware, and strangely enough the Virgin Islands, also require that a plaintiff have suffered a deprivation of liberty consistent with the concept of seizure as a consequence of a legal proceeding. And this essentially means that you need to have been arrested, held pursuant to a pretrial detention. I've had recent cases where someone simply received a citation, and as a matter of law, those citations, because the person was not held pursuant to them, did not constitute a seizure. Some jurisdictions also require proof of actual innocence, which is an additional level of proof required, I believe, in the state of New Jersey. The cause of action in malicious prosecution accrues on the date the underlying criminal proceedings were terminated in the defendant's favor, which is usually either the date that the charges were dropped, or the subject was found innocent, or that a conviction was overturned. The damages in malicious prosecution claims run from the date of charging, and this permits damages for confinement imposed after legal process. Retaliatory prosecutions in retaliation for the exercise of rights protected by the First Amendment. The elements there are that the conduct that the plaintiff engaged in was constitutionally protected, that the protected expression was either a substantial or a motivating factor in the defendant's actions, and that there was no probable cause for the prosecution. Then we have due process violations, and this is going to be the primary cause of action for those that have been convicted and are serving their sentences, and it can encompass almost any sort of wrongdoing by a law enforcement official or a prosecutor. It includes suggestive identification procedures during a photo array or a lineup, withholding exculpatory evidence, which is also known as a Brady violation, which we'll discuss shortly, the knowing use of perjured testimony, coerced interrogations, witness intimidation, or inappropriate plea deals in exchange for witness testimony. And as we spoke before about Brady violations, this comes from the U.S. Supreme Court case of Brady v. Maryland, and the takeaway from that is that the suppression by a prosecution of evidence favorable to the accused upon request violates due process where the evidence is material either to guilt or to punishment, and this is the important takeaway, irrespective of the good or bad faith of the prosecution. Joe will talk about Brady violations shortly in relation to prosecutors, but law enforcement officials have an affirmative duty to submit exculpatory evidence to prosecutors. So every police officer, any exculpatory evidence has to be produced to a prosecutor. And while courts are not clear, police officers may have a good faith defense to a Brady violation, whereas prosecutors do not.
So now we're going to talk about how do you defend these claims once you've been sued. Whether the suit is for false arrest, false imprisonment, malicious prosecution, or a civil rights violation, the essence of that defense is proof of probable cause. The problem comes in that the lawsuit is filed many years after the events which trigger the claim. Recognize that in the wrongful conviction cases, what happens is the arrest occurs, a prosecution occurs, a criminal trial occurs, there's then a reversal of the conviction at some course, and then after the reversal of the conviction, most likely, is when suit is filed. Not always, but often. What we're talking about is years. In those cases in which the victims, or I should say the defendants, become plaintiffs because they were wrongfully convicted of, say, perhaps rape, they may have served as many as 10 years or 15 years. You've heard cases Charlie talked about where people were in jail for over a decade for crimes that they were cleared for by DNA. So these suits can be brought 20 years after the events in question. Thus, it's a challenge to prove probable cause. Cases which I've handled in which rapists, convicted rapists, were then cleared through DNA testing, what I would do and what I recommend be done is that you still bring the victim in and have them repeat the testimony that they previously gave. That is, this individual is the individual who raped me. In the case I had, that's exactly what the victim said. She looked at the picture of the guy who had been cleared through DNA and said, that's the guy that raped me. Now, that doesn't always occur, but at least you get the testimony that the person was firmly of the belief that they accused the right person of committing the crime. So over time, because notes can be lost or reports can't be found, it's going to be difficult to retrieve them. Rely upon having the individuals talk about what they thought at the time and what they saw. Law enforcement officials may reasonably rely upon statements that they were given. So you can have the individual show them that statement and have them repeat, this is what I was told, this is what I saw, and I had every reason to believe that it was true. You would walk the victims through the crime, and you would have them repeat the accusations that they had made years before, and thus prove that it was reasonable for the prosecutor or the arresting officer to rely upon it. Now, negligence. In a civil rights case, negligence is generally inadmissible and not sufficient to prove that there had been a constitutional violation. The exception for that comes in the cases involving prosecutors. Prosecutors are prohibited from pursuing a case which they know to be unfounded, meaning if they know that there is exculpatory evidence, prosecutors have an affirmative obligation to turn that over. If they fail to do so, the plaintiff has proven a case against them for malicious prosecution, and thus negligence is sufficient. Likewise, in the civil rights arena, for a due process violation against the prosecutor, proof that they knew that there was false testimony, knew that the witness was committing perjury, is sufficient to prove a civil rights violation. Now, that's not necessarily so, and it isn't really so when it comes to anyone other than a prosecutor. So if you're talking about a police officer, negligence isn't sufficient. But when you're talking about a prosecutor, in the few instances that I've just shown you, proof of negligence will do it. Now, under the Heck doctrine, cases involving false arrest, false imprisonment, malicious prosecution, and retaliatory prosecution or due process wrongful conviction all require that the plaintiff prove that his conviction was overturned. If the conviction was not overturned, those cases do not have a proper foundation and will fail. However, there are cases that survive even if the suing plaintiff was convicted of the crime. For example, excessive force. They may have been convicted of the crime, but still have a valid cause of action for excessive force if in the course of the arrest, the officers exercised excessive force in the course of that arrest. Likewise, in terms of challenging the unreasonable search or seizure, they may still bring a cause of action for that while having been convicted of the crime.
And one exception to the excessive force and Heck doctrine is that if someone has been convicted or pled guilty to resisting arrest, Depending on the state and the nature of the state's laws for resisting arrest, the Heck Doctrine can bar an excessive force claim. I had a case in Pennsylvania. The statute in Pennsylvania states that the officers were required to use substantial force to overcome the resistance of the criminal defendant. In that case, the plaintiff had pled guilty to resisting arrest, and the judge determined that as a matter of law, the force that the officers used did not constitute substantial force, and so we were able to use the Heck Doctrine to have those claims dismissed. But it is rare and will depend on the definition of resisting arrest state by state. I know in New Jersey that is not a strategy that is available based off the definition of resisting arrest there.
Okay, claims against law enforcement officers. Absolute immunity applies for all testimony. However, courts are split as to whether or not this absolute immunity would apply if there was a conspiracy to give false testimony. Qualified immunity, all officials should be protected by qualified immunity. Now, there's some discussion as to what is qualified immunity, and let me just say to you that a general rule of thumb in understanding qualified immunity is whether there was a knowing or intentional violation of a known right. Qualified immunity is an affirmative defense. It is something that the defendant must affirmatively prove. It's a condition precedent to the plaintiff proving that they have a valid cause of action against them. So the plaintiff may, for example, prove that their right was violated. Years ago in the civil rights era, when they were protesting, there's a famous case in which the kids in high school were wearing black armbands. The principal prohibited them from wearing black armbands in the school zone, and that case went to the United States Supreme Court, in which it established that they had the right to free speech. It was a First Amendment right to wear black armbands in the school. Well, how was the principal supposed to know at the time that he or she banned the armbands that it was a First Amendment right? No way to know. So that case is used for teaching a known right. The principal acted in good faith and did not knowingly or intentionally violate a known right. So qualified immunity, also known as a good faith defense, is used where you can prove that it wasn't known at the time that it was illegal to commit the conduct which the defendant is accused of. Prosecutors. Charlie and I have both defended a number of prosecutors over the years. To be quite honest with you, it's easier to defend a prosecutor than it is a lot of other people. Although it's difficult to work with lawyers in general, it is more easy. It is easier to defend a prosecutor. Nevertheless, while there is the general rule that prosecutors are absolutely immune from prosecution in the act of being a prosecutor, which means the initiation of prosecution and the pursuit of prosecution, the exception to that rule generally is that when they perform administrative tasks, they don't have absolute immunity. The fight is what is an administrative task, and that's the area of the law that needs to be addressed. But the general rule of thumb is that prosecutors are absolutely immune from prosecution, that is, from civil suits and civil liability for the decision and the act of prosecution. However, that doesn't apply if they suborned perjury or if they brought a case in which they hid evidence or in which they knew that the case was not a viable cause of action. Putting it another way, a way in which they knew they didn't have probable cause and they never should have prosecuted. In those arenas, that is an exception to the absolute immunity that prosecutors have. So, under the Brady Doctrine, if they have not turned over the evidence that they were supposed to turn over, those prosecutors do not have absolute immunity. Claims against governmental entities. Now, oftentimes those of you who are involved in the defense of these civil suits see that the police department is a named defendant. Actually, the police department is not a suable entity. Likewise, the district attorney's office is often named as the defendant in the suit. They too are not really a suable entity. The actual entity to be sued is the municipality in which the district attorneys are located, the county that employs them, and likewise for the police department, the borough or municipality, the township that employs them is the proper named defendant. In the civil rights arena, a civil rights claim cannot be brought against a municipality for respondeat superior, for what's known as vicarious liability. The landmark Supreme Court case of Monell holds that it has to be a custom, policy, or practice. And thus, what the law says is a single incident, more likely than not, is going to not be sufficient to prove a claim viable for a civil rights violation against a municipality. You will establish in a successful defense that there were policies or practices or procedures in place to protect the victim's rights, and thus the plaintiff cannot prove that it was a policy, practice, or custom to do these events. Plaintiffs are allowed to get around this by proving that training and supervision were such that it was deemed to be a policy or practice. Thus, it's important for you in defending these cases to prove what the training, policies, or practices were. This is an area that is very ripe for litigation. Damages. As you probably know if you've handled any of these civil rights cases, the most valuable part of it is oftentimes counsel fees. Thus, in a false arrest case, if a person is detained for 5 minutes, they might be entitled to damages for the emotional distress of having been detained, as well as perhaps the cost of having to hire an attorney and the time it took them to appear in court. But the real exposure comes from the fees brought by the civil rights attorney in prosecuting that case. A prevailing party in a civil rights case, pursuant to federal statute, is entitled to an award of attorney's fees. And thus, unlike the common law that we inherited from the English, we award and promote attorneys to bring these types of cases, and oftentimes the most valuable part of the case is the fee-shifting part of the case that comes from the plaintiff's attorneys. A rule of thumb that we like to tell our clients is take our fee, multiply it times 3, and that's what you can expect will be claimed. The unfortunate part of all this is you lose the case, you owe fees, and then you have to litigate how much you owe. So it gets more and more expensive. Thus, the best thing to do with these civil rights cases, if you can't win them outright, is to get rid of them early.
And final thing we'll be discussing today are coverage issues. Now, this can be a major issue for carriers because the question will be, when did the cause of action accrue? This is sometimes known as the trigger of coverage, and that activates the insurer's obligation under a policy to defend. And this will depend on state law. The majority rule is that the trigger occurs on the date the wrongful act occurred. And for example, the trigger of coverage for a wrongful prosecution claim will be the initiation of the wrongful legal process itself. The minority rule, which I believe is in roughly 17 states, is that the trigger of coverage occurs where the cause of action accrues for the purposes of the statute of limitations. This, in the case of a malicious prosecution claim, would be the date of exoneration. And that this is also complicated due to the fact that you can have different causes of action occur over multiple policy years. And so we've seen carriers become involved with very expensive litigation to determine which carrier or carriers is on the hook for which percentage of any settlement or award at post-trial. Just a quick example would be that a false arrest claim could occur in 2007 under one policy year, while the due process violations for failure by a prosecutor to provide exculpatory evidence could occur in 2008 or 2009. You have different policy years. You could have potentially different carriers who have to determine which portion of the damages should be apportioned to which policy year. And this is often complicated by the fact that, as we all know, governmental entities, particularly smaller municipalities, may have difficult times retaining their documents, may have misplaced a policy, or we're talking about a case that was from 16, 17 years ago. They may have been discarded completely. Retention policies are different over time, and so it can be very difficult to determine even which carrier was on the hook, depending on when the wrongful act occurred. And in conclusion, wrongful conviction claims are some of the most difficult claims to defend and can have some of the highest exposure for insurers, in addition to the high level of media coverage these generally receive. They're very difficult and they involve scientific evidence proving that the plaintiff conclusively did not commit the acts in which for which they were convicted. They involve some of the most heinous allegations against law enforcement officers or prosecutors that could be imagined, including drafting false reports, withholding evidence, forced confessions, manipulating witnesses, planting evidence on the plaintiff, and they involve highly sympathetic plaintiffs who have lost years, sometimes decades of their lives to incarceration, and so they also can also include significant collateral emotional distress claims. These are people that have been in prison for decades. They may have experienced abuse in prison, and even if they haven't, they've lost many, many years of their lives that they're never going to be able to recover. Difficulties of defending these claims include the fact that reports and evidence are decades old. Criminal investigations have notes, reports that may have been destroyed or lost. You can have witnesses that are deceased, missing, or simply forgetful. Especially when we're talking about multi-decade-old convictions. The facts of these claims are also less likely to lend themselves to summary judgment than a sort of a typical false arrest claim, where the wrongful act allegedly occurred 3 or 4 years ago, and some person may have spent a day or so in jail. These claims are going to be very difficult for judges to dismiss, simply because the plaintiff spent years in prison for a crime they didn't commit. It's going to be very hard for a judge to make that call, even if the facts and law are very strongly on your side. So today we'd like to thank you for attending our webinar on wrongful conviction. You can learn more about this program and all other Weber Gallagher events at www.wglaw/WG-University. Thank you for your time today, and we look forward to following up on any questions you may have offline. Thank you.
Thank you very much.